humane approach to supporting refugees. I urge the Government to listen to them.
Joanna Cherry.
You, Dame Rosie. I rise to speak to amendments 121 and 123 to 127, which are tabled in my name, and also in support of Amendment 1, tabled in the name of the Right Honourable Member for Aberavon, who speaks for the official opposition, to which I've added my name. And I've tabled these amendments as Chair of the Joint Committee on Human Rights. I'm not going to push them to a vote because the committee has only just commenced our legal scrutiny of this bill. That's not because we're dilatory in any way, but because it's been bounced on us at such short notice. We've got very little time to undertake that scrutiny, but we hope to report before the bill has finished its passage through the House of Lords, and at that point I hope we'll be able to recommend some detailed amendments with the backing of the whole committee. Dame Rosie, I did wonder whether it was worth my while spending hours in the chamber this afternoon waiting to speak in detail to any of these amendments, as after 6 hours of debate yesterday, the Minister made no attempt whatsoever to address any of the detailed points raised by opposition amendments. Now, we don't expect the Minister to agree with us, but we expect him to at least do us the courtesy of addressing what we have bothered to say, not just on behalf of our constituents, but also on behalf of civic society and so on. That's how democratic scrutiny works. There's no point in members opposite banging on about the sovereignty of this Parliament when the Government ignore most or all of the substantive points raised by the opposition during legislative scrutiny. Dame Rosie, that's not how a bill committee is supposed to work, and I would appeal to the Minister to remember his duties not just to the Government and his political party, but also to this Parliament and to the constitution of this so-called parliamentary democracy, because the way we are legislating in this House at the moment is an absolute disgrace, Dame Rosie. A bill committee is supposed to be line-by-line scrutiny. This is a fairly lengthy bill which raises huge issues in respect of our international legal obligations and also huge moral issues. But we've not conducted anything like line-by-line scrutiny. And if I'm supposed to keep my comments to 10 minutes, I'll barely scrape the surface of the amendments that I've tabled, and have not just been dreamt out of thin air. They're informed by detailed legal scrutiny of the bill by those lawyers advising my committee, and also many of the amendments are informed by the existing unanimous report of the Joint Committee on Human Rights on the Bill of Rights. So, you know, this bill sneaks in some of the things that were going to be in the Bill of Rights. And yesterday, as I say, I spent quite a long time addressing in some detail the legal reasons under reference to the Convention and case law of the European Court of Human Rights, the reason why it would breach the Convention for the Government to ignore interim orders of the Court. And I also explained how very rarely interim orders are passed in respect of the United Kingdom. And the Minister just completely and crassly ignored every single point I sought to make. And frankly, his behaviour, I'll take an intervention in a minute, the behaviour in failing to address any of the opposition amendments makes a mockery of this Parliament, and it makes a mockery of all their singing and dancing and fuss about the sovereignty of this Parliament. So I'll take an intervention.
Grateful to the Honourable and Learned Lady for giving way. Yesterday, my Honourable friend, the member for Stone, set out a very compelling argument about the sovereignty of this place. But I share her concern that I think that speaks to an earlier time of how laws were made, where it was done in a far more leisurely way, where this place made far fewer laws, and it took its time. There were no programme motions. People could take as long as they wish to. So I take her point entirely, and doesn't that speak to the importance of scrutiny in the other place, but also some oversight of the courts, so that if there is error in our lawmaking, the courts can point it out and we can rectify as and when necessary. So I fundamentally agree with the point which she makes with regards to the importance of court oversight.
Order. Before the Honourable Lady responds, just to say I gave some guidance. As she knows, it's not possible to impose a time limit. My guidance was to try to get as many people in as possible. Joanna Cherry.
making that clear, Dame Rosie. Just to answer the honourable gentleman's points, yes, I do think in a civilised, balanced, modern democracy where we have proper separation of powers, the role of the courts is very important. But the role of this chamber is very important. I'm not too bothered about the other place. It's not elected. It doesn't represent people. I got elected, went to the trouble of getting elected 3 times to represent my constituents. What I have to say about this bill is an awful lot more important than what some unelected peer has to say. And I say that with all due respect to many of the peers who I think do a fantastic job in trying to fill in the holes of the absolutely appalling way in which this government seeks to pilot legislation through this Parliament. Yes, I'll take another intervention.
I'm very grateful to give her. I fear I wasn't clear because I was trying to support the Honourable and Learned Lady in what she was saying. In that I referenced the other place as, of course, in a bicameral system, that the second house provides time to reflect and then obviously give us their views, which we can then consider again. But the fundamental point with which I thought or hoped, hopefully agreeing with the Honourable and Learned Lady, was the point that she makes, as do others, of the importance of being able to have court oversight, because we are inclined to rush our legislation in this place. And therefore, if we do get things wrong, we are only human after all, it is important to have space for the courts to reflect, to hear evidence, and to advise and guide.
Yeah.
I know he was trying to assist me, but I agree with him that court scrutiny is important. Of course I do, I'm a lawyer. But I'm not going to let the government off the hook on the absolute woeful scrutiny that goes on week in, week out in this place. I'm totally in favour of a bicameral system. When Scotland eventually becomes independent, which I hope will be during my lifetime, I would like to see a bicameral system in Scotland, because I like to see checks and balances. And I don't like governments who throw their weight about and don't allow proper legislative scrutiny. And that's what that's my point. That's why I'm spending some time on this just now, because the way this is being conducted is frankly a disgrace. It really is a disgrace. Right.
I'm very grateful the Honourable Lady is raising these points, because as the Chair of the Home Affairs Select Committee, we were very keen to carry out some pre-legislative scrutiny on this bill to assist the House when it came before us. That wasn't possible because it had to be rushed through, it seems. So we've had no opportunity to have evidence sessions or to do any of the work that would really help the government. It seems to me, why are the government so frightened of proper scrutiny of this bill, which we all recognise is so important?
I can tell her why they're so afraid of proper scrutiny, because proper line-by-line scrutiny of this bill will illustrate that it breaches our international obligations under the ECHR, it breaches our obligations under the Refugee Convention, it breaches our obligations under the Council of Europe Action Against Trafficking, and that's just to mention 3. There's also the International Convention on the Rights of the Child, and I could go on and I could go on. That's why they don't want the scrutiny. And what really infuriated me yesterday was that when some of us were actually trying to make arguments that were based on evidence and the law, the Minister was far more interested in parroting the populist slogans coming from his back benches, which really had no basis in law and no basis in evidence, than addressing the amendments we are trying to make. So I am going to spend a bit of time talking about the amendments I've lodged, because I think they're quite important, not because just because I think they're important, but because I think they reflect issues that have been widely raised in briefings by the even just speaking about home-based organisations, briefings by the Equality and Human Rights Commission, the Scottish Human Rights Commission, the Law Societies of England and Wales, the Law Society of Scotland. I can absolutely assure the members opposite, the Law Society of Scotland is not a bastion of lefty lawyers. I wish it was, but it isn't. So anyway, let's just start with Amendment 1, which is an amendment to Clause 1. And the purpose of that amendment is to prevent Section 3 of the Human Rights Act from being disapplied in respect of this bill. Because if that happens, it means that the courts will be prevented from interpreting this legislation to avoid human rights incompatibilities in provisions, unless those provisions are ambiguous. And what will happen then is that the court will be far more likely to issue declarations of incompatibility instead, which, and I notice that the Minister, despite everything I've said, is now conducting a lengthy and casual conversation with the chap sitting beside him, rather than... This is just not how we should be conducting ourselves in this place. In my previous job, if I sat and held a conversation with the barrister or the advocate sitting beside me when the other advocate was speaking, and we'd have got a telling off from the judge, I just think it's nothing to do with me. It's just wholly disrespectful to the process of parliamentary scrutiny. This is really important. The Human Rights Act was passed by this Parliament. All of the responses to the government's consultation on the Bill of Rights and all of the responses, or the vast majority of the responses to my committee's consultation on the Bill of Rights, showed that people thought Section 3 was working really well, and that Section 3 of the Human Rights Act does not undermine parliamentary sovereignty, because it can only be brought into play where provisions are ambiguous. Yet despite all of that evidence and despite all of that scrutiny, the government is wanting to go ahead with disapplying Section 3 of the Human Rights Act to this bill. And what I want to know by tabling this amendment is I want to know the basis for that. How can the government be so confident that their view, which is in direct opposition to the responses to their own consultation, the weight of them, and the responses to my committee's consultation, how can they be so confident that their view is right? I think we all know the answer. They're not confident that their view is right. They just want to drive it through on a wave of populist rhetoric. The next amendment I want to speak to is Amendment 123, which is designed to seek to ensure that the United Kingdom will comply with its obligations under Article 31 of the Refugee Convention. Now, insofar as the government actually hasn't explicitly addressed the compatibility of the bill with the Refugee Convention in the documents which accompany the bill, but I understand that the government's argument is that protections under the Refugee Convention only apply to those who fall within the group who cannot be penalised under Article 31, that is to say, those who come directly to the United Kingdom. And this is the phrase the government relies upon to justify its interpretation that asylum seekers should claim asylum in the first safe country they reach. And that's reflected in the third condition set out in Clause 2, which says a person is not taken to have come directly to the UK from a country where their life or liberty were threatened if in coming from such a country they've passed through or stopped in another country outside the UK where their life and liberty was not so threatened. And in practice, that would exclude any asylum seeker who travels to the UK by any means other than a direct mode of transport from the persecuting state. Now, that is clearly not the intention of the Refugee Convention. The government's definition of coming directly, set out in Clause 2.5, is inconsistent with the interpretation of Article 31 in the Refugee Convention set out by experts assembled by the UNHCR in 2001, who concluded, following analysis of the Travaux Préparatoires, that the drafters of the Refugee Convention only intended that immunity from penalty should not apply to refugees who found asylum or were settled temporarily or permanently in another country. And the government's position is also inconsistent with the similar interpretations of Article 31 made by the English High Court in the case of Adimi and others against CPS and the Secretary of State for the Home Department, and that their interpretation was discussed by the House of Lords by no less than Lord Bingham, who said, in another case of ASFAW, which confirmed that a short stopover in another country on the way to claiming asylum in the UK does not preclude reliance on Article 31 of the Refugee Convention. So there is binding authority from the highest court in England that the government's interpretation of Article 31 of the Refugee Convention is wrong. It's also noteworthy, Dame Rosie, that the interpretation of coming directly in this bill is much stricter than the interpretation set out in the Nationality and Borders Act 2022, which states that individuals will not be considered to have come directly only if they stopped in another country and could not reasonably have been expected to claim asylum there. So it is worthy of comment that the government has substantially altered its understanding of the legal meaning of a well-established international treaty in the space of a year. on the basis that I think they're trying to say there's some sort of evolving interpretation. But if actually you look at the interpretations both by our domestic courts and in the convention, the government are wrong, and the interpretation I've set out is correct. Another amendment I want to speak to, Dame Rosie, is Amendment 124, and that would remove the prohibition for the first 28 days of detention on the grant of immigration bail by the first-tier tribunal and the ouster of judicial review detention. I'm not going to go into the details of that because it's actually quite complicated, but I think the government's contention that to fall back on habeas corpus would fulfil our Article 5 commitments under the ECHR. I think that's highly dubious, and I really hope that they will Minister, perhaps, or his boss, the Home Secretary, will come before my committee so that we can discuss these things in a bit more detail than we are able to do today. And then again, Amendments 125 to 127, these are designed to ensure that the disapplication of modern slavery provisions extend only in accordance with the Council of Europe's Convention on Action Against Trafficking. And that's been spoken to in some detail already by a couple of honourable members, right honourable members opposite. So again, I'm not going to take up more time talking about that. But I just want to end with one or two other comments. During the debate, several honourable members have spoken about the plight of women in Iran and Afghanistan. And I'm not really quite sure how the government thinks a woman who's fleeing the persecution of women in Iran or Afghanistan can come legally to this country, particularly in the Iranian case. And I'd be really interested to hear what the answer to that is, because it concerns me, Madam Deputy Speaker, that the third condition, Dame Rosie, it concerns me that the third condition in Clause 2 of this bill is that in entering or arriving, as mentioned in subsection 2, the person didn't come directly to the UK from a country in which the person's life and liberty were threatened by reason of their race, religion, nationality, membership of a particular social group or political opinion. I just wonder why sex is missing from that list. Because some of the most serious persecution going on in the world today is against women on the grounds of their sex. I've mentioned Afghanistan, I've mentioned Iran. We also know about the weaponisation of rape against women in war zones. People talk about Ukraine, but it's happening in Africa all the time. Now, I know the honourable gentleman, the member for Aberavon, has an Amendment 2 to add the word gender to that list, but I think the word should be sex. Gender is a social construct. These women are not being persecuted on the basis of a social construct. They're being persecuted on the basis of their sex. And I think something where I and the Minister can agree is that the United Kingdom should be very alive in its global outreach to protect women's rights. So I would ask the government to consider adding sex to that list. Now, my honourable friend, the member for Glasgow Central, also said that we should be adding sexual orientation to that list. And I completely agree with her on that because of what's happened in Uganda in particular. But there are many other countries in the world where it is not legal to be gay. It's not legal to be gay in Iran. They still hang people from cranes in Iran for being gay. So I think we need to think about that. Now, the Minister may very well say to me that membership of a particular social group, I think, is traditionally interpreted to include LGBT people and trans people, but not to include sex. So I think we need to add sex to this list, and we need to be clear that it includes LGBT people as well. And I think I'll just leave that there for now, Madam Chair. Thank you.